So our next presentation will be a presentation on dismiss and refer process with Judge David Brannon, Magistrate Brittany Doggett, and Prosecutor Amy Musto.
To my right is Amy Musto. She's been a prosecutor for 21 years. She's a little bit unique in that she's been in a couple of counties. She's coming from Montgomery, working mostly in Dayton, and now newly with Columbus, which is nice. She's extremely interested in the dismiss and refer process, and she's here to provide mostly her experience and maybe best practices. To my left is Brittany Doggett. She's a magistrate with Probate Court in Montgomery County. She's been there for a couple of years, and I've been on the bench for 3 years in my first term. I am just the guy in the room. I wanted to mention real quick, the forms that Justice Stratton mentioned are civil commitment forms for probate. We love our forms. Traditionally, for decades, we've had no civil commitment forms. We had forms for estates, guardianships, adoptions, all these things, but not civil commitments. So that's what's new. Those will be forwarded to the Supreme Court, hopefully for approval. AOT is our next project. That'll be starting May 10. Quick shout out to Judge Wiles in Wayne County. She did a lot of the work. Magistrate Doggett and Judge Park. So I just wanted to clarify that. This is a little bit of the Wild West with the dismiss and refer process. And Brittany, why don't you just mention what dismiss and refer is for everybody?
Sure. So just a little discussion on this. So really going back kind of to SB2 is when we've really been pushing for this. But basically, this is a process that allows individuals, a little higher, sorry, from the criminal court to be referred over to the probate. So they're basically individuals who are criminal, usually found incompetent and unrestorable in time, but they still need treatment. So instead of just letting them go into the streets, you can actually refer it over to the probate court, where then as long as they meet our criteria, we can get them assistance, get them treatment, and try to get them kind of stabilized so that they can be basically returned to the community. I do also want to note, we use the phrase dismiss and refer, but there are a lot of different languages used right now. And I just want to kind of note, I think, Betsy, when you have it from the TAC, that they're pushing for a dismiss upon civil commitment with AOT, because an AOT is kind of an important part of the dismiss and refer process.
And I mentioned it was a little bit like the Wild West. I think there's a little bit of, you have to have trust between the courts, the prosecutors, public defenders, and everybody involved. I know some counties flat out won't try it. We're here because we're willing to try it, and it's, you know, you hear things and you don't know, so you get everybody like this in a room and find out what.
I've been asked to talk to you about the dismiss and referral process from the prosecutor perspective. And what we found is that the most important thing is communication. And I think that's already been talked about by other individuals who've spoken here today, and I think we're all aware that that is the key. And then sharing of information is also very important as well. When we are looking at these cases as prosecutors, I think the first question people have is, why would they want to do this? And the thing that we have found is that when people are found incompetent, not restorable, we cannot prosecute them at that point, but they are still someone in need of services. And if we don't find a way to provide those services, we're going to see them again, and probably very soon. And so that motivates us to try and collaborate with other individuals, including the Public Defender's Office, defense attorneys, the probate court, the Animus Board, other providers, in order to try and get these folks the treatment they need. The advantage is for us, maybe we see them less, maybe we don't see them again. And so that's why we wanted to collaborate on this. So I've come from Dayton Municipal Court, and in that court we have a prosecutor review process for all of the filings that we take. And so rather than officers just filing the charges directly, every case is reviewed in the prosecutor's office. And that gives us the opportunity to review the case at the front end and look for these issues and see how we might help. As we review these cases, there's several stages at which we look at this case and have considerations. So I was going to go through those different stages. We talk about it at the intake stage, then pretrial assessment or quick set trial assessment. How do we get that competency evaluation done and the issues that we face with doing that? And then the evaluation results and what we do from there. So first I want to talk about the intake assessment process. As I mentioned, we review the cases when they come in. And we've developed a lot of tools through our collaboration with the probate court and the defense bar to help us to do this more effectively. One of the most recent developments is the ability to see on JusticeWeb what cases are open with the probate court, if individuals have an open probate case. This has been really invaluable, but because before that, we may have an individual we could recognize as having mental health issues, but we'd have no idea if they were in treatment or services, what those treatment and services looked like, or if they'd had any contact with the probate court. So by having that information available to us, that's one piece of the puzzle that allows us to know if this is someone, we need to begin thinking about that. We also look to see if we've had past contact with these individuals. A lot of times we have the frequent flyers who come back over and over again. And we look to see what the police reports and other charging offenses that we have are going to tell us about it. What's the nature of this offense? Does the officer recognize that there may be mental health issues? Are there issues that we can spot through the actual offense? You know, someone is saying things that seem outlandish or not in touch with reality. It cues us that this could be a case we want to look at. We sometimes have recent competency reports as well, where we can look and see if we've had contact with this person and what those reports look like, that history. And all this information helps us to start moving the case in the right direction early on. So, what do we do with that information? Well, once we've evaluated the case and seen that this may be someone who we want to point that direction for, we sometimes reach out to the Adams Board right then, or we reach out to the probate court right then. They have an open case, they're actively in a probate case involvement, they're actively involved in their case. We may not want to take charges at all. We may want to just refer the case over to the existing probate case. The fact that this individual is usually in jail at that time gives the probate court a unique opportunity, particularly for folks who are difficult to track down due to limited housing issues. And so we try to reach out to them in order to enable them to know where this person is and to get services connected with them. If we're able to do that with someone who already has an open case, then that lets us move forward more quickly in getting folks out of the jail and into the services they need.
Yeah.
Just on JusticeWeb, when Amy mentioned it, it's a homegrown system out of Montgomery County where it's a lot of information is pulled from a lot of different databases, probably 200 agencies. It's expensive, it's tedious, it's a little bit old. It's just one of those systems built on systems. It works though, and they use it. Some of this comes down to just sharing information, which we all know is helpful. The more information out there, the better. I'm going to get myself in trouble, but Montgomery County is one of 2 counties in Ohio that I know of where the probate court's docket is online. We don't show images. It's much like Hamilton County, but the feedback we get from families, from law enforcement, from the social workers, the hospitals, is that thank you, we can actually see what's going on to see who's under commitment, but also hold people accountable. There's that accountability aspect. If somebody doesn't file something, it shows up. I look at the superintendent's rule 55C. That gives probate court judges the authority to divulge mental health records.
That sharing of information and then collaboration. Prosecutors and defense attorneys don't always get along too well, but it really is an important point of collaboration. I think sometimes the attitude from the defense bar has been, well, I just want to get my guy out of jail, I don't care after that. And I think it's short-sighted, and I think that the defense bar has begun to see that that is a short-sighted idea, that the goal really should be to get the person the treatment and services they need in order to not have them get arrested again next week for the same or similar charges. And so we've started communicating more with them at these early stages. If we have a case that we see may have competency issues, we'll highlight it for the defense bar so that when they go over to the arraignment hearing and meet with individuals for arraignment, they already have the information. This could be someone they want to look at more closely. That helps us to move this process along more quickly. Time is of the essence. Everything we do in this process takes time, and so the sooner we can get together the information, recognize what needs to happen, and move forward, the more effective that it is. So as I said, we evaluate this case at different levels. The next assessment we have is at the pretrial. At that point, they've been assigned counsel. They've usually been in jail. In Montgomery County and Dayton Municipal Court, we generally hold people in jail who have mental health issues in order to try and get them assessed, particularly if it is someone who has had several offenses of the same nature. We find if they are given an OR bond, they end up going back and doing the same thing. And then there is a difficulty with getting people back into court. I know that jail is not the ideal location for these individuals. We do not have a mental health facility that we can house them in this pretrial manner. And so this is what we are stuck with for the time being. That is something that we would hope for is an alternative to that. When they have someone in pretrial detention, though, especially on a low-level offense, the time that they have to prosecute the case goes very quickly. And so as a prosecutor, we have to assess whether or not we want to continue to hold someone in jail. If we can find family and support and other people to allow this person to be out on their own and still meet appointments to be assessed for competency issues, we try and do that if we can. If they are without resources, without a place to live, oftentimes they will remain in jail. And that's where it becomes very important that we move forward as quickly as possible. It is our hope that by the time we get to a pretrial conference, the defense counsel has had a chance to speak with their client and that they have had a chance to evaluate that competency is appropriate and file a motion for competency evaluation. If they haven't moved forward to do that, it really does cause delays in the case. Once they have filed that motion, we're looking to get that evaluation done as quickly as possible. And so the defense bar buying into this process, wanting to see people receive treatment if they cannot be prosecuted, is a really important component of this. And meeting with them, developing those relationships has been important as well. The other thing we try and do is something that was mentioned. If we can find family, friends, support individuals for this person and gather that information, it helps us to get them to the treatment they need ultimately. So we try and gather that information as we go along, coordinate, if we can, an outpatient arrangement for that individual, out of jail arrangement for that individual, in which they can still get to appointments, but they are not in the jail. So the next thing we need to do is get that competency evaluation done. And it is important, there's a lot of moving parts to getting this done. We need the judge to order the evaluation efficiently. We need to contact the agency that's going to do the evaluation and get that done in a timely fashion. What I have seen in my short time in Columbus that I like is a centralized evaluation. We have one individual who does the evaluations, and that allows everybody to know who's going to do the evaluation. It allows for a more efficient, streamlined process. In Montgomery County and Dayton Municipal, we would have multiple different people doing evaluations out of the same agency. These folks handle other cases and other aspects of mental health care. And so they can't always get to people as quickly as we would like them to. I think that that has improved, and we're getting evaluations done in a more efficient manner. But working out a process, working out individuals who can be committed to getting these evaluations done quickly and efficiently has been a very important process, part of moving this process along. Again, we have to evaluate if we're going to hold this person in jail or we're going to release them. And we have to really consider that maximum sentence issue, because if we do reach that point in which they've served their maximum sentence, we cannot refer the case to probate. And there's nothing sadder to me than seeing someone serve weeks in jail only to not have the report in a timely fashion and not be able to get them to the services they need. Yeah, it's been a little bit varied. When we first started doing this, we were looking at 20 to 30 days to get an evaluation. Now we're getting a more efficient process going. At least when I left we were getting the evaluation done more quickly. But usually it's 2 to 3 weeks before you get an evaluation back. So time runs quickly and time is of the essence. Once we get the results of that evaluation, again, time is of the essence. We need to make sure that the court is scheduling cases as efficiently as possible. As soon as we get that report back on competency, we need to bring that individual in, especially if they are in jail, as quickly as possible. We do have considerations for Marcy's Law issues if there are victims in the case, and so we need to have time to notify victims so they can be present, be part of that hearing. But we need to move as quickly as possible because time is running. Assuming the person in this scenario, our assumption is that this person is found to be not competent and not restorable, then we need to again decide about detention issues at that point. The court is authorized to hold someone for 10 days after the finding of not competent, not restorable, in order to allow them to be processed to the probate court. It is very important that when we get those evaluation results, the court move quickly and efficiently in getting their entry on, in holding that hearing, so that the probate court still has time in which to do what they need to do to process this person over.
Here's one that we talk about a lot. Some defense attorneys want to use prior evaluations. So the question for you, Amy, is can I use a prior evaluation, and how much time between those prior evaluations, if the answer is yes, that you can use those?
From a legal standpoint, the prosecution can ask for a new evaluation every time the individual is arrested. That would be what the legal answer is. Practically speaking, we have tried to work out a system to allow us to extend that. If someone has been evaluated in the last 6 weeks, we generally will rely on that evaluation in order to make the process more efficient in getting the individual to the probate court and to mental health services, and also to control the expense of doing evaluation after evaluation on the same person when we already have a very good idea what the results are going to be. There's pushback from the defense bar. They would like to see us rely on evaluations that are much older than that. But our understanding in talking to mental health professionals is that with competency being something that is going to change over time, that really 6 weeks is as long as we should be looking back, and that it could change even quicker than that. So we do it with caution. It's not a hardline rule. If we believe there may be changes that are significant where another evaluation should be done, even within that 6-week period, we will ask that another one be completed. But we are trying to work with the system in order to get people where they need to be as efficiently as possible, and relying on that 6-week look-back period allows us to do that. So we get the results of evaluation. What do we do now? Well, there's a lot of considerations as to whether or not we're going to refer the case for probate. I would say 9 times out of 10 we do. We want to see people get the mental health services they need, but we have to make a determination if they are appropriate. How do we do that? Well, we look at the nature of the offense. We consider the recommendations of the competency evaluator. Most often they will give us a recommendation as to whether this individual is appropriate for mental health treatment and would benefit from mental health treatment. We also rely on the recommendation as to whether outpatient or inpatient treatment would be appropriate in evaluating whether or not to send the case on. We would also consider if we tried to probate this individual before this, and has that been successful? Have they engaged in treatment and services? I think that we recognize that it's not always going to take the first time. We may have to refer people to probate court more than once in order to get them to engage in services. And so we're willing to give people multiple tries, but at some point you have to recognize that this is just not working. And this is not going to be an effective method and effective use of our time and resources to make the referral in those cases. For the most part, though, we are still early on in this, and we are referring cases even from people who have been referred before and not engaged in services. The only other consideration is whether or not they are really appropriate for it. If someone has an organic brain injury or something that is not something that would benefit from treatment, not that everyone wouldn't benefit from treatment, but in the legal sense, that we don't refer those cases because they don't meet the statutory requirements.
And one of the things I'm just going to talk about then is when the case is sent over to the probate court, part of our issue is trying to get the correct paperwork. So these cases actually come over with kind of a small amount of information. So we're receiving the affidavit, copy of the evaluation, and Oftentimes, what we are missing might be things like the Social Security number, which usually is needed by our Adamus board to try to start getting the person set up with an outpatient provider or an inpatient provider. So we actually have a confidential form that is sent over with our paperwork that has just a little of that demographic information. The court doesn't really use it, but we can forward it then to our Adamus board to get them kind of going on trying to find a location of placement. One big thing with probate is once the affidavit is basically sent to us, we have to have an initial hearing within 10 days. And oftentimes, we are trying to also work with how long the person has been in the jail. As Amy mentioned, the criminal court can hold them for up to 10 days. So those 10 days may not be running at the same time. We try to schedule these almost immediately. Most of these individuals are individuals who are in the jail at that time. If it is one where we have a new affidavit filed, we have to have an evaluator go out, do the evaluation, and then we can bring them for the hearing. So usually that's 2 to 3 days we have before we can bring them over. If it is an individual who's actually got an open probate court, we set those for a status hearing, and we can bring over the individual as long as we know we can get their case manager from their agency. Another thing is just we do get affidavits from both courts and the prosecutors in our county. So Dayton Community Court, we always get it from the prosecutor. However, we have outlying courts that will send us from the judge directly. And part of that is then trying to figure out if they're missing a piece, who gets contacted. So oftentimes we don't get the entry that gives us basically dismissing the case to give us jurisdiction. So we're having to either reach out to the prosecutor, we're going to reach out to their office. But if it's a judge, we're oftentimes trying to find a bailiff, trying to find someone who can get us that form. One of the other things just with that is also how the hold works at the jail, because the criminal court is sending over the hold, but the probate court is the one who is having the hearing. So it's coordinating that to make sure that they recognize when those 10 days are up, they have to go even if we've not held the hearing. And also that once we've had our hearing, that person needs to be out of jail basically immediately. So they've seen probate, if we've ordered inpatient or outpatient, they're going to inpatient or outpatient that day. Another just thing that part of this, I think, overall system is just communication, but we do communication on multiple levels. And when we're dealing with the individual trying to get over to probate and also trying to get them out, we're oftentimes working with family members. So if we order somebody to outpatient, a family member is usually going to be who picks them up from the jail. And also, do they have an appointment, a sheet of paper that's going with them, telling them when they are supposed to go to their outpatient provider.
I think just to give you an example of the communication issue, it's taken about 1.5 years to get the stakeholders in Montgomery County involved, and that would include law enforcement, hospitals, treatment providers, justice partners, all the courts, prosecutors, defense attorneys, commissioners, umpteen others. And once you do that, I mean, we meet bi-monthly. I kind of run that meeting, but there's several other task forces that have been combined into it. So once you get all those people in the room, you start seeing actual results. And you know, at our end, we're getting ready to flip some switches, which we're excited about. E-file, things like that. But you can't coordinate these people without everybody going through that painful process, flow charts and checklists, and we're only a portion of the way through. Oh, you? Sorry.
That's good. And so one of the things I do want to talk about is just from our point of view, these cases actually aren't really that different from the cases we would receive from an emergency hospitalization or from somebody filing in the community. The way we handle the case is the same, same sort of criteria, all of that. The real difference is in how we do the coordination on these cases. So as I mentioned, sorry, I'm terrible with the microphone, but a lot of it is coordination with the jail. So when we receive an affidavit, and it's a good affidavit, we do have some issues. Sometimes we get some that are moderate intellectual disabilities. That's not one that works with mental health, and oftentimes it's a complete different situation that we can handle in any way. But for those that are good, we almost immediately reach out to the jail upon receipt and just let them know, hey, this is an individual with the probate, have gotten the order from criminal court. We're going to probably be setting them for a hearing within the next couple of days. So they're aware. As soon as we actually have that hearing date set, we also send that over to them. This person is going to be, or needs to be brought to the courthouse. We are very lucky. Our jail is right across from our courthouse, so the sheriff's department does bring over the individuals, so we don't have that transport issue that some other courts may have. And we also are pretty lucky on the fact that if we have to do a quick hearing, so it's one where it's an individual needs a status hearing, they're already under probate, and we're on a time crunch, they'll usually work with us and have them there the next day. We also do a little bit different with our evaluator process for the individuals. As Evie mentioned, we have a hard time with a lot of these individuals finding them. They tend to be transient. Oftentimes, they're in the shelter, but we don't know when they might be at the shelter. So we do usually have them stay in the jail so that we can get the evaluation done. As I said, we turn them around pretty quickly, just so they're not being held. But we have one evaluator who actually does our jail evaluations. So she goes out, does the evaluation, and she'll be ready for our hearings. We don't really have multiple people going in and doing the jail evaluations. And so because of that, we actually have a set form we immediately send over to the jail with that individual's name on it so that they can just know she's coming over to do the evaluation and they can release their medical records to her. And then we do a lot of coordinating with the ADAMIS board on placement on these individuals because if we have them in emergency hospitalization, they're already in the hospital. But we are actively, from kind of the time the case comes in, looking for a bed for that individual. If possible, we actually would like to move them from the jail to the bed before the hearing. A lot of times it just doesn't happen. The other issue is some of these individuals we have coming through have actually been trespassed from our local hospitals. So it's trying to figure out if there's another hospital in the region we can get them to, or if that's not going to work, then it's do we go immediately to outpatient. We did have an individual who he was actually through our system a couple of times. He had gotten trespassed from all the hospitals, even though the recommendation was inpatient. So we had to place him outpatient, but it was the time it clicked for him. So he is actually doing really well right now. He's going to his treatment. And it was just the fact that we still kind of worked that system. When he left the jail, he left with a parent who had his time set. Here's where he has to go. He had one. I think we had everybody who could possibly know within the HIPAA requirements that he had that appointment and he made it. And as I said, he's doing really well right now. So it's just trying to figure out what's going to work for the individual and that coordination. We have one concern is we have to do a lot of it by email change. So you have a lot of trying to communicate where you can't actually say the person's name, but most of us know who it is, things like that. We also actually do a lot of coordination with the public defenders because even when the case is dismissed, they're just concerned, are we going to see this individual coming back? So they're trying to make sure they've actually been placed with the provider and are receiving the treatment, so they're not going to end up picking up another charge.
From mine, it's a trust issue. Many courts, particularly, why should we turn them over to probate court if you guys aren't going to do anything? Traditionally, in our court, after 90 days, the commitments would expire, and that's it. Then we're back in the pink slip process or the dismissal referral process again. I think from a probate court's end, we just need to watch our dockets and show we're trying to do something, whether that be AOT or some other sticklers in our system. Like we give notifications to the out-of board that an expiration is going to happen. Just anything to show that we're trying to keep these people on our dockets.
Best practices is kind of where we want to go from here. One person, one evaluator is important. A small group of individuals who become your experts on how to do this also helps as you're trying to communicate and coordinate between the jail, the ADAMIS board, the prosecutor's office, the public defender's office, and all the other players that have to be involved in this. Having a centralized person that you can go to in order to coordinate those efforts is really important. And having everyone understand how the work is going to flow and what the logistical issues are is very important as well. Yeah, so we talked a little bit about who needs to be at the table and how important that is, and that we have probate court, criminal court, prosecutors all meeting together, and it really is key to having that work out. And then sharing data amongst those individuals is also extremely important. making sure that we are all on board, all understanding what this individual's situation is. If they do have an open probate case, making sure that we're not kicking that case by initiating a new probate case, which can cause problems in continuation of care.
And then the last thing that I think I just want to mention is also the discharge notice is really the communication back to the court and the prosecutor on what has happened. And so that's when we've actually had a little bit of difficulty trying to get from our entities we commit to. And it leaves a sort of gap where the court doesn't know if that person ever got treatment, anything like that. We try to communicate back as the probate court, but that's one of those where it's really a work in progress for us in making sure that everyone is moved back into it. So that's one of those ongoing issues that we're working towards. But we also have the issue where sometimes even the probate court isn't always informed when someone leaves our local hospitals and is actually now put on outpatient. So those issues that occur, in the full process also can cause problems here within this. And I think as Judge mentioned, we've been working on really getting our AOT program up and running, because these are a lot of individuals who need the kind of wraparound services that AOT can really provide.
Dr. Gortz, I don't know how we are on time, but I think we've covered what we wanted to cover, and thank you for listening. You're welcome to contact any of the above. If you've got questions or we can share anything, thank you.